experienced midwife and has worked in many countries in the world with very different cultures of more medicalised or less medicalised birth. And because what he's seen in all these environments, he has more recently become a focus of his work is human rights in childbirth for women, for midwives, and he has trained subsequently to support midwives. He's doing a lot of work with our independent midwives at the moment who need it, and he has vast knowledge which he's going to share with us today. So thank you, Paul.
Hello. Before we start, let's do this experiment of being aware of their breath. So we connect to our breath. The awareness will help us connect to the whole session. So just become aware of 3 breaths. As you're breathing in, be aware of the breath coming in your nostrils. Breathing out of your mouth. Just taking a moment for your own quiet time to breathe. So I'll start to talk. I mean, I'm basically a travelling midwife who's accidentally been in many countries and at many births and stood up for women, for the families and for midwives. What I'll do here, I do have a presentation, but a bit more hopefully courageous than giving you a set thing, is to go with the flow. When we go to a birth, we can have a set idea in our mind how it's going to be, but how do we know? When we walk in there, things change. We don't know until afterwards how it's going to be or when it's going to be. So with this session, it's not going to be fixed. I really welcome challenge. If I say something that strikes a chord with you or you have a question on, please shout it out. Okay, so a tiny bit more about my background. I'd already spent some time in North India before I did nursing and then midwifery. So I'd already seen a different way of a culture being very loving and compassionate, which is how life generally is, I find, in the more developing countries like India. I was back there a few weeks ago for the Human Rights in Childbirth conference and realised how we are one big family. We might have different titles, midwife, doula, hypnobirth. We're all a family, we're all in it together, and sometimes we feel a bit weak and need someone to strengthen us. So hopefully by these coming together we share ideas and strengthen our resolve to action things. Action is an area where we often fall down. We can be in a hospital and it won't let us do something. I shift the power very much to the woman. If she declines something, we cannot do it. So I'm going to follow on very much about the cord clamping subject. Before I get into flicking through some slides, with the cord clamping, the action that can be done is the woman declining to have immediate cord clamping, and that gets anybody out of a difficult situation with their employer or with any guidelines. I teach law, and one of the things I teach is criminal law, as well as looking at midwifery regulation, so there's great variation. In criminal law, we all know there's stealing, there's theft. The word for this often is appropriation or misappropriation. If we deny the baby its own blood when it's born, that's theft. Whose blood is it anyway? Was on the slide. So there's always another side. When I've been a midwife practicing physiological third stage, not interfering, and the manager will come and say, no, you're not allowed to do that, you must do such and such. Actually, by knowing what our rights are, what the baby's rights are, we don't even have to say anything, we can just carry on. So I'm hopeful today that discussing our rights will make us feel more empowered ourselves with our rights. So a baby's blood belongs to the baby. Misappropriating it is theft. Somebody could sue for that. Instead, we're all worried about being sued for not following the guidelines. And those on a regulatory register, the nurses and midwives, will have their regulator threatening constantly. And the cases I deal with, the number one thing is, did your woman have informed consent? How do we know it was truly informed consent? How do we know you didn't brainwash her into your hippie, leave it alone physiological thing? And Their view is a little bit supported by the Supreme Court in the UK, 2015 Montgomery case. Anybody heard of the Montgomery Lanarkshire case? I see a few nods. Any hands up for... So some people have heard of it, not a lot. But the main point of the 2015 Supreme Court in the UK, Montgomery, was that clinicians must discuss risk, no matter how small the risk is, of anything that the clinician is advising. But interestingly, there's a risk about life. There's a risk about getting in the car, whether you put the seatbelt on or not. There's a risk whether you have a home birth or a hospital birth of greater interference in the hospital. But we do have this obligation on us, and the regulator has picked up on that and saying, how do we know that you didn't talk the woman into something? So long as midwives are documenting risks discussed, possibly what all those risks were, then they get off the hook with the regulator. But being under the spotlight does affect people's practice. We need to flip it around. The woman has complete autonomy over her body. I actually heard something on TV yesterday that in a rape situation, the consent is a process. So boy meets girl in a bar, they go back together, she consents initially, she changes her mind. I thought, well, this is the same in labour. A woman says, okay, I'll have my waters broken, but no, I don't want the drip. You had your waters broken, therefore you've consented to the drip, because that's what we do. And if the drip doesn't work, something else, you've consented to everything, now you're here. Does that mean, I'll throw this out as a question to pause and think, that when you walk into a hospital, do you consent to everything that's done to you? Yeah. There's a wonderful phrase in law. They used to use Latin a lot, and we shouldn't. I think it's, you cannot volunteer to be injured. That's an established principle in law. There's a few exceptions. 2 boxers in the boxing ring. Or you go to a high-risk physical event, like boxing. But generally, you cannot volunteer to be injured. So when a woman comes into the hospital, ends up having an unwanted episiotomy that may be unnecessary, that's a clear violation. So before I do this, I'm still going to stay with the criminal aspects of law. In a way, I'm working from the end backwards. The criminal aspects involve theft, I've mentioned, but they also involve assault, battery, and trespass to the person. An assault is, I'm going to thump you hard in the face if you don't do X, Y, Z. It's the threat that's realistic of violence. But if I'm little and you're really big and I say I'm going to thump you in the face, it's not a realistic threat. But a battery is the unwanted touch. So anything, if we walk up to a pregnant woman and just start to do something, I'm just going to do this, we have to have her consent. Often we get that by body language. Somebody will look, they will smile, they will nod. That's consent. If you're happy, it's consent. Everything doesn't have to be documented and video recorded in case we're in a court of law. Trespass to the person. Is that a phrase anybody is familiar with, the words trespass to the person? So if you think about trespass to property, our body is property. And somebody doing something to us, what we deal with is immensely intimate, private, and a woman needs to feel safe. It's not just about vaginal examinations, as we'll hear later from Mary Stewart. Again, the big theme I feel today is informed consent, and there's an extra word we can add on. Has anybody got that extra word? Informed consent and choice and refusal. That's it, pause with that refusal. Because informed consent can be bamboozling the woman with so much information this way or that way. So the midwife is saying, there's lots of research that supports not being induced. Then perhaps sometimes a doctor may come in and say, well, your baby's going to die unless we do this induction. Your water's been gone more than X number of hours. So both of them might be selling it in a particular way. What we have to know is that the woman understands, and how do we test a woman's understanding? In general, it would be that she has asked appropriate questions. So again, for the registrants having to defend their practice, they have to say that they explained the risks, and then the regulator will say, how do we know you explained the risks? Because she asked appropriate questions. And if somebody's written that down, it's another green tick that you are less likely to come under fire from the regulator. So there's a real balancing act for those that are regulated. For those that are not regulated, could be a midwife that gives up her registration, could be a doula, could just be a woman working with a woman, could be a man working with a woman. They have a lot more freedom. So what we're dealing with always is fear and love. Now, if you're at a home birth, or if you've got animals, you'll have seen them giving birth. They don't even know. If there's a bit of fear, they just run off. Or they bite the fearful person. They find a safe space, they give birth. The human animal needs a safe space. We need to be left alone. And we've got various litigation things. Now, I live and work a lot in New Zealand for over 25 years since the law changed, promoting independent midwifery practice there. Also in New Zealand, they have a no-fault compensation scheme. There's a scheme in Sweden, which is kind of a rapid response or reaction to when an event happens, sort it out, talk to the parents, include them, admit what you've done wrong. We all know this, and when even some hospitals in the UK have adopted things like this already, their rate of complaints have gone down almost to zero. Open disclosure is often a phrase that's used. Kind of forgetting my thread there, somebody remind me. Okay. This is the problem of being like a stand-up comic. It is more courageous to ride the wave of see where this goes, where this conversation goes. And I will be looking at some questions. So just talking about, and I'll finish off on criminal, which I never normally talk about, but I decided today to think about whose blood is it anyway? And when we've got that respect in us, we walk into a room and somebody has said, they need to have X, Y, Z. Yeah, but have we asked them? It's theirs. It's their body, it's their baby, it's their baby's blood in the case of cord clamping. But it's this woman and her partner's decision for whatever we do. And just by holding a space for respect of them, I think it translates into respecting each other and ourselves. And the biggest issue we have globally, or one of the huge ones, is retention of midwives. So the whole planet, even New Zealand where it's wonderful, and they have that no-fault compensation system, retention, what do you think, and I'll ask for a bit of a shout out, what are the reasons for lack of retention? You might be familiar with this country or America or maybe Scandinavia, anywhere else. Why do you think midwives leave? Exhaustion? Lack of autonomy. Because you're criticised, you're quite right. Why are nice guidelines called guidelines when your regulator will beat you with a stick saying you did not follow the nice guideline? It's a hierarchical problem, an autonomy problem, exhaustion problem, defensive, fear, litigation. I find a simple one also is respect. And what we've got with guidelines and legislation is a generalisation. What we've got in this room is a bunch of individuals, and if one person were in a birth room with them, that is a unique individual situation. So for me, I'm suggesting to you that is a get-out clause. Whatever you're criticised for not following a guideline for the registrants, you just say, however, I'm mindful of the guidelines, I have insight, I can demonstrate my knowledge of the guidelines. If we act ignorant, they want to sanction you and send you on more training and things like this. If you say, yeah, I accept that, I've read that, I've been on a study day, good, but the unique individual circumstances meant that my clinical decision was based on a lot of information, which is equal to have intuitive information. I will step up and defend anybody in any legal situation, that intuitive information is equal to or as valid as evidence-based information. Because we know that body language is everything, it's why we're here, we're not reading a book. If you're at a birth and something's happening and you know something to be right, but at the back of your mind you're keeping an open door, you could always be wrong, so you're being very mindful and appropriate, you can justify what you did as reasonable. If somebody's critiquing your care or the events as unreasonable, they have to show the evidence, how and why. What happens though with our regulator in the cases I go to, however kind and benign they appear as individual personalities, their culture is they're looking for something wrong, they've got a fear-based culture, they're afraid of their boss and all of this.